Cool. So this is actually quite an interesting question. We were engaging in a debate about this just before we started. Now, the concept of fair wear and tear is something that we hear about, especially as landlords and agents. But you know, do we really have a grasp of what comprises fair wear and tear versus damage to property versus lack of cleanliness? And you know, basically the concept of return a property the way that it was, save for. And how do these kind of fit into the scopes? Do these overlap? Are there instances where one needs to consider one above the other? So in this example, it was actually a case of a unit that had a disabled tenant. And unfortunately, this caused either damage to the carpet, dirt that can't be cleaned to the carpet, or fair wear and tear by an innocent landlord that was simply wheeling himself around as he needed to.
Perfect. So when we're dealing with fair wear and tear, this is one of the more complicated questions that we get all the time. And it's one of those questions that doesn't have a simple answer and really depends on the facts of the case. So just to go back to basic principles, basically in terms of a lease agreement, obviously a landlord gives a tenant a free use and enjoyment of the premises under the obligation that when that property is handed back to the landlord, it must be given back to the landlord in substantially similar condition that it was received in by the tenant. And then there's a caveat in law which says that fair wear and tear accepted. And all that means is there is a recognition within our law that while a person is using a particular asset, while you are living within an immovable property, there is going to be some level of wear and tear as a result of everyday use of this particular item. So the law recognizes that it's not reasonable to expect that if I give you something in an exact condition, that exact condition is returned to me, because this thing is in essence going to be used every day by people moving in it or having furniture in it or whatever the case is. Okay, so there's an expectation that the thing is handed back. There's an exception for fair wear and tear. Now, the question often arises within our law and within lease agreements: what does fair wear and tear constitute? Okay, and as I said at the start, this really depends on the facts and circumstances of the case. So fair wear and tear, as we understand it in law, is just normal use of an item for its normal purpose. Okay, so walking in and out, or using door handles as they're intended. A great example I always give my agents is if the door handle starts to get a bit damaged because you're opening and closing a door, that might be fair wear and tear. But the minute your kids hang on the door handle and pull it out of the door, okay, that's no longer fair wear and tear. And I think you can see the example there. But now that question becomes a lot more complicated in different circumstances. And in this particular circumstance where you've got a tenant who is using a wheelchair in a premises, and now they've been using the wheelchair and there's been some damage, it's a question of, does that constitute fair wear and tear? Does it not constitute fair wear and tear in the circumstances? So there's a couple of components to this. The first thing is there's some expectation. Obviously, a person who is disabled, who's using a wheelchair or some other form of mobility assistance, there's going to be a different kind of fair wear and tear by using that mobility assistance in the premises. Okay, there's no way you can have an expectation that someone who's not able to walk, is only going to make foot marks in the particular premises. It's simply not possible. So there's going to be some different level of fair wear and tear expectations in respect of this particular premises. And it must be remembered, in terms of the Rental Housing Act, there is a clause in terms of the Rental Housing Act that you are not allowed to discriminate according to ability of people in respect of your tenants. So there has to be some adjusted expectation of what is fair wear and tear in the circumstances. That, however, also needs to be met with some obligation on behalf of the tenant to make sure that in using the property, even though they're using the property with an assistant assistance with the wheelchair in the circumstances, that wheelchair does not then cause further damage to the property, or as Bruno pointed out, further perhaps dirt or dirt or something like that in respect to the property. So a great way of thinking about this is you are perfectly entitled to walk in and out of a rental property as you please. But if you are tracking in mud every day and walking in and out of the property, okay, there is a level of expectation on you to guard against the damage which you have caused as a result of that. Okay, you can't just say it's fair wear and tear. I've tracked mud into the house, every day. Now the carpets are stained with mud. There then is an expectation that you ought to have done something to protect against the damage in the circumstances. So there has to be a balance in respect of both parties in the circumstance. The question of whether it constitutes fair wear and tear, this is one of the more complicated questions, and it depends entirely on the facts of the case. So this is the thing that, as Bruno said before, we were having a debate about whether a wheelchair access would constitute fair wear and tear or not. And the truth is, it is entirely dependent on the facts of this particular case, and is something that Bruno and I, if we were sitting in court, we'd have a long debate about our opinions on whether it is or isn't, and that's why lawyers are here. But for the purposes of just briefly going through this, there's got to be an understanding of, if we're taking the wheelchair example, if there are indentations in the carpet as a result of the use of the wheelchair rolling over the carpet, that's something that can be probably determined to be fair wear and tear in the circumstances. But the minute it goes beyond that and becomes a staining or something that could have been avoided, if there was cleaning or something, mud's been tracked in and that shouldn't have happened in the circumstances, that is where now it tips beyond fair wear and tear of the property, and now we talk about, okay, is the tenant actually liable in the circumstances as a result of failing to protect against the damage, or in this case, this sort of staining of the carpets in respect to the property. So just a comparison. Again, as I say, this is going to depend on the facts. It's going to be a huge debate in court, and generally why fair wear and tear arguments are, we try and avoid them as much as possible because they're completely contentious.
Absolutely. Thanks so much, Nick.
Perfect. Thank you, Bruno. And then we will see you again next week.
Awesome. Have a good one.
Yes.